allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Senate Judiciary is now in session. My apologies, we ran a few minutes late. To use the word loosely. Okay, 57. Representative Muse. There you are. Good to see you. Seemed like only a few minutes ago, but it was hours ago I told you it would be here a little earlier, I believe. Tell me about HB 57.
I will do that. HB 57 was requested at the, was actually submitted at the request of the Department of Corrections. What it would effectively do is allow a person under the control of the department who's been approved for release under administrative home confinement to participate in post-secondary educational opportunities in the community where they've been accepted for enrollment. So these opportunities include a range of options beyond high school, including college courses, courses at vocational schools, universities, and more. Under our current law, residents in our state prison system who are approved for administrative home confinement are authorized to take part in employment in uncompensated public service outside their home, as long as they return to their home within a specified amount of time. What the bill would effectively do is add attending college courses or post-secondary vocational courses to the statute. And that's really all it would do. What it doesn't do is change eligibility for the program, anything about the process itself or any other aspect of the law. It also would not change any of the department's policies surrounding administrative home confinement. And to be very, very clear, this is not a program that anybody in the state prison system is eligible for. Anyone who has had disruptive or violent behavioral issues, or who's been convicted of committing an escape or aggravated DUI or one of a long list of other crimes, is not eligible for administrative home confinement. It's also worth pointing out that this is a process that's separate from the parole process, and inmates are eligible to apply for it once they reach 18 months before their sentence. And in order to be approved for it before your minimum sentence has been served, you actually have to get the permission of the judge in your trial court as well as the prosecutor.
Very good.
So these folks would actually be monitored at home by the Department of Corrections Division of Field Services, and we actually have someone here who will testify from the Division of Field Services about how that would work if you have questions. Any tuition payments would be the responsibility of the inmate, so it would be up to the inmate to pay tuition to obtain any scholarships. There would be no cost in terms of educational expenses to the state of New Hampshire. And I think one of the things that's worth noting as I did research on this is that the results from programs like this are tangible and they're very real. There have been studies by the RAND Corporation and the Vera Institute that have found that incarcerated people who participate in college programs are 43 to 48% less likely to be reincarcerated than those who don't. And employment rates for formerly incarcerated students also increase on average by 10% after participating in these programs. So these people actually come out at the other end more employable, which is a good thing. I would ask you to please support the bill. I have probably exhausted my knowledge of this particular subject matter, but we do have folks from the Department of Corrections who can answer your questions.
How did it come out of the committee?
It came out unanimous ought to pass from the Criminal Justice Committee and went on consent in the House, and it passed on consent.
Thank you. Questions, Senator? Okay. Good. We're good. Thank you very much.
Thank you.
Nicholas Duffy. Good afternoon. Sorry we're here so late. My apologies. I'm in a good mood. The Celtics won, so take as long as you want.
Two more, right? Thank you for having me. My name is Nicholas Duffy. I'm the Director of Rehabilitative Services. I'm not going to repeat what was just said for time, but again, is just a couple quick things. Is this doesn't change eligibility requirements. It really just adds the ability for somebody who has been accepted to post-secondary education to do that as part of their at-home process. So they would still, as part of the packet, they still need to make sure that they have housing. They still need to have, sorry, let me repeat that, appropriate housing, a way to support themselves, programming supports in the community. Although none of that changes, it really just adds the ability to for post-secondary education services.
Okay. Questions? Come on. Or you do? Okay.
Thank you, Mr. Chairman. Thank you for staying and having a conversation with us. When I read the bill, the amendment here, and I saw qualifying offenses, I'm glad to see that your testimony then outlined, I assume 1 through 11 are persons that would not be able to participate in this program. Is that correct?
Yes.
It made it easier for me. Thank you, sir.
Okay, seeing no other questions, thank you.
Thank you.
Janelle LaPlante. Good afternoon.
Good afternoon, Mr. Chairman, members of the committee. My name is Janelle LaPlante, and I am a psychology researcher with the University of Massachusetts Chan Medical School. And I just wanted to briefly testify in support of this bill. I'm familiar with a great amount of research literature that speaks to the value of pro-social activities. So positive things like employment, educational opportunities for folks who are justice involved or at risk of justice involvement. And so I think this would be a really powerful way to empower folks to make more positive choices. And so I just wanted to express that.
Very good. All set. Come on. You're usually better than this. Come on, more. Good. Thank you very much. And Reverend Mark Pearson, are you speaking or not speaking? Okay, you got no in the corner. Okay, I'll put the glasses on. Thank you. Seeing anyone else wish to testify on the bill who didn't get a chance? Seeing none, that'll end the hearing. Yes. For 480. Okay. Sullivan, I don't think so. I asked if anyone else wanted to speak. I'll go with no. You've been waiting to do this for a couple weeks. Come on up, Reverend Pearson. We're now going to take up HB 480, the Honorable Reverend Mark Pearson. Good to see you, buddy.
Thank you, Mr. Chairman. This bill is designed to address the problem of competency restoration for persons who are charged with a criminal offense but are found incompetent to stand trial. Under current law, there is a time period within which they are either restored to competency or else their case is either dismissed or they are considered for criminal commitment if dangerous. Unlike most states, New Hampshire has nothing in place to assist in restoration. A recent news article reported how the Hillsborough County Attorney took our state's forensic examiner to task because a growing number of individuals were not restored to competency and as a result were let go from prosecution. Depending on the year, the percentage rate of restoration to competency in New Hampshire has been between the high 30s and low 40s. Since there has been no focused program, these individuals either got better on their own or they acquired competency as an incidental byproduct of other mental health treatments. By contrast, states with focused programs in place had a restoration rate between the high 60s and mid 70s if done on an outpatient basis, and 81% if done inpatient. This bill as currently written establishes two ways to assist with restoration to competency. First is the hiring of one or more forensic liaisons. A liaison would facilitate the defendant's attendance at initial competency evaluation and at any treatment appointments. Too often, defendants default because of non-attendance. Additionally, a liaison would assist in obtaining services for competency restoration and communicate with the court as to the defendant's progress. The second way this bill seeks to help is the contracting for service providers. Competency restoration treatment is a subcategory of mental health treatment. Because the majority of states have such programs in place, we need not guess or theorize what our treatment program might look like. Objections made by the few opponents we've encountered to this are readily addressed by a study of how the other states have dealt successfully with such objections. This bill, if signed into law, would bring closure for the alleged victims of crime. It would also bring closure to the alleged perpetrators. They would be found either guilty or not guilty now. Additionally, we have seen instances where the sentence given to somebody found guilty was actually shorter than the time they had spent in a mental health facility or jail without competency. In crafting this legislation, I brought together senior members of our Judiciary and our Department of Health and Human Services, as competency to stand trial is at the intersection of what these people represent. We agreed DHHS would be the place for the forensic liaison to be cited. Interest has been expressed in 2 of our counties for a pilot program. While the department has said that they do not know how many staffers would be needed for the pilot project, yet we have somehow seen a fiscal note of over $1 million. Not only does this seem rather interesting, how can we do a fiscal note if we don't know what we're doing? And it also seems quite excessive to those of us who have worked considerably on this bill. However, the principal parties and I all agree that given the financial picture of the state, now is not the time to go forward with this bill, yet we don't want it defeated, which would render it inoperative for 2 years. Rather, we would ask for the Senate to re-refer this so that the principal parties can do further refining of how restoration could be accomplished, and a more comprehensive, improved version could come forward later on when, we hope, some money can be found. Thank you, Mr. Chairman.
Thank you. Senator Reardon, you good? Okay, good. Thank you very much. Good testimony. Thank you. Holly Stevens.
Chairman Gannon, members of the committee, my name is Holly Stevens. I'm the Director of Public Policy at NAMI, New Hampshire. And I'll try to make this brief to maybe help you get back on track a little bit. I know I spoke with the chairman yesterday that we are in agreement with the recommendation for re-referring. It was NAMI, New Hampshire who asked this bill to come forward. We do believe with the tight budget that the state has currently and the uncertainty with the language of the bill, that having a little bit more time to work on it and maybe seeing if there's funds to bring this forward next year is the best course of action. we have heard from several of our folks that it can be a missed opportunity when they're found not competent to stand trial, and that there are no services provided, that our families see that their loved ones end up reincarcerated for other offenses, that they end up homeless or back in an institution. So having a competency restoration program in our state is really important, which is why we wanted to see the bill go forward in a good form that can pass and can set up a pilot program that works.
Thank you very much. Questions? Thank you very much, Holly. Janelle LaPlante.
Good afternoon again, Mr. Chairman, members of the committee. My name is Janelle LaPlante, and I'd like to briefly speak in support of House Bill 480. So for just over 3 years, I worked as the Chief of Psychiatry's assistant at the Alaska Psychiatric Institute, which has a forensic unit, which I also volunteered on, a forensic competency restoration unit, which I volunteered on over the course of a year and a half, working with forensic psychologists, observing competency evaluations, supporting them with programming, working with forensic social workers, and the like. I did testify before the study committee back in the fall, and Chairman Pearson was very kind to do me the honor of inviting my continued collaboration on the project. He asked me to reach out to other states, get a sense of their competency restoration processes. And so I was able to connect with a gentleman in Colorado, a conversation I'd like to highlight because he spoke very highly about their equivalent of what we're proposing here in New Hampshire, Forensic Navigator program. And he did say that he truly believes that the forensic navigators play a pivotal role in the success of the competency restoration program in Colorado. And that is something I'd like to highlight because a forensic psychologist, Dr. Shannon Bader, back in the fall, spoke very highly about Colorado and their competency restoration process. And additionally, I'd like to highlight that there is scientific literature that supports something like the forensic navigators as well, so both anecdotal and research evidence that supports this idea. And I'd also like to speak in support of taking some extra time to fully consider competency restoration. I think that the Forensic Navigator Program is a great starting point, but I think that there is great benefit to considering other ways for a comprehensive competency restoration program. Thank you.
I think I had one left. I've lost my little hearing sheet. Anyone else wish to testify? Good. That's 2 for 1, so that's better. Good afternoon, ladies. How you doing?
I'm Karen Rosenberg. I'm the policy director at the Disability Rights Center, and I brought one of my colleagues who is I would consider much more of a subject matter expert on this than I am.
My name is Hannah Roberts. I was a public defender for about 4 years, where I represented people for whom competency was raised and was pending. And I'm now a staff attorney at the Disability Rights Center. I represent people with serious mental illness and serious persistent mental illness.
So our office does support the re-referral of this bill. We think that there is some work to be done to really get the most bang for the buck here. While we think that having a liaison program makes a lot of sense, a pilot, we think that it's lacking in a few areas that we are hoping our office will be invited. Well, I'm hoping Hannah will be invited to address. And those areas include establishing a program in which there's some trust developed so that the defendant is more likely to engage in the process. Also, looking at what services might be recommended. And also we would hope to see some data collection that could be used by the Committee on Restoration of Competency for further recommendations it might make, including, whether it would be helpful to know what barriers there are to engagement in treatment and in attending the evaluations, all of that. So looking at those things and bringing that information to the committee so that it can make evidence-based or data-based decisions on the future of this program. So thank you for your attention. I know you're real busy. if anyone has questions for me or Hannah. Thank you.
Anyone else wish to testify on 480? Seeing none, other than hearing.
So moved.
I'm making an sorry. What's that? Sorry. Yes.
Yes.
Motion to refer. Do I have a second?
Second.
Okay. All in favor of the refer motion?
Aye. Motion to come out of executive session?
Thank you.
Aye.
Teamwork. Loving it.
That's the way we roll here.
That's why the Celtics won. It was a team effort. What's that? I can't, I don't really, yes, three in this file. Representative Juliet Harvey, come on down. Okay, we're hearing House Bill 143. Representative Harvey is going to walk us through. Thank you. Yep. Okay, thank you.
Thank you, Representative.
Pete will do the work next time. Just hand him, throw the pile at him.
Thank you so much, Senator and members of the committee. I know you've had a long day. We were all listening and rapt attention all day to your session, so we were right there with you. But I'm Juliet Harvey Bolia, Belknap 3, and I'm here to introduce House Bill 143 relative to the issuance of no trespass orders on municipal or school district property. The problem that this bill is seeking to solve is lack of due process as far as no trespass orders. When you get a speeding ticket, at the end of the speeding ticket at the bottom, it tells you how to have redress, or to, if you want to, it shows you how to appeal your ticket if you don't think it's fair. But unfortunately, for some reason, we just haven't spelled that out in our statutory laws here in New Hampshire. And it has resulted in some fallout, as you might have guessed. That's why I am here, based on some history that we've had. So I did a little bit of research on it, and quite a bit of research, but we have this guidance in a lot of other states. The Massachusetts ACLU has a lot of guidance on the fact that you do need due process for no trespass orders. Vermont School Board also has, Vermont School Board's Issuance Trust also has, can a school bar a person from school grounds using a notice of no trespass? And they say, short answer, a school should only use a notice against trespass order as a last resort. If utilized, it must be narrowly tailored. So in other words, it can't be something blanket or something broad. It's a last resort, and if you issue a no trespass order, especially to a parent or somebody who's interacting with the school, it should be quite narrow. So all this is kind of stuff that you can find online. It's pretty well documented. I found a lot of stuff from the Massachusetts ACLU, as I mentioned, that also points to the fact that parents and legal guardians have a right to attend school meetings and functions related to their education of their children. So thus, NTOs that prohibit parents from attending conferences, et cetera, encroach upon that right. Generally, NTOs should not interfere with regular school activities like picking up your children from school. So I'm just gonna, so I gave you a little packet. I'm not gonna talk about any of these cases. I know it's late. But what you have, I'm gonna, in chronological order, I'm gonna go with, the first thing that we have in by date is in 2014, there was this case of Jeffrey Pendleton, which is pretty famous. It's this big packet you have here. And he was just a homeless person who was outside of a library. They ended up jailing him for 30 days, and unfortunately, Mr. Pendleton died in jail, so the case never got resolved. But this ACLU briefing is extremely exhaustive, giving reasons why we need due process. We need that at the bottom of the no trespass orders. So it's quite an interesting read. Let's see. The next one is an item that has been emailed to you all, and I'm not going to go into it. It is a letter from Representative Power about a constituent. And on the back, it kind of gets to the summary. I kind of highlighted it in yellow. And long story short, in 2022, this gentleman, a resident of a town, is trying to use his transfer station, the recycling center. Words were exchanged between himself and another resident. It got spicy, and they gave him a no trespass order, which is still in effect to this day. He has been told by other employees that he can use the transfer station, but then he got something in the mail saying he can't, and it's from an employee. So it's another example of no due process. He's never been offered a hearing. And it's very sensitive information, so I'll let you read that on your own. And then finally, most recently in 2024, was the famous case of the Bow parents, which I'm sure you're all aware of. There's a copy of their no trespass order here, and you can see on the second page, there is no offer of a hearing, although it's very clearly well crafted. They put a lot of effort into it. I'm sure there were lawyers involved. But I think what it comes down to is, these people who are trying to do the right thing, the municipalities and schools, and they're clearly reading the law, but they are just not thinking about that due process part of what they need to be putting in there because it's simply not in the law. So when their attorneys get involved, they see they're meeting all the aspects of the law, but they're just not getting that due process part. So the House saw fit to pass the bill, and it passed almost unanimously on the House floor. And they did change one thing about how it is to be determined at the school board, say it's a school board, whatever the governing public body is, we had a disagreement. We weren't sure whether it was supposed to be, a super majority, a majority, or unanimous decision. So that's one thing that was changed. But otherwise, it just sort of spells out a process. And I think that is it. Now,
This one I look forward to putting some thought into.
I'm sure. Yeah.
Senator? Questions? No? Nope. Good. Appreciate your time. Thank you for coming in. And food for thought in a rainy weekend, something to do.
Okay. Thank you very much. I appreciate it.
It's a week, I'm sorry, yeah, it's the weekend. It's gonna rain. What am I thinking of?
Right.
Thank you very much.
All right.
Appreciate it.
Thank you very much.
Yuri Fulovov? Sorry, bro. I guess we are a little late for some people. Miss Christina? Looks like she's not here. Okay. Eric Power?
Help you with that.
Good afternoon, Chairman Gannon, members of the committee. My name is Eric Power. I'm from the town of Brookline. I am currently the president of an organization called School District Governance Association, which focuses on school district governance issues across the state. And I also served as the on the Hollis Brookline Cooperative School Board for 3 years term. And the way I look at these no trespass orders in private makes sense. If you don't want somebody coming, you can do a permanent one on someone. But when you start doing a no trespass order on public property, you're denying somebody their rights. And right now, there's no standard for what the no trespass order is. There's no review process. There's no due process. There's no time limit. There's no who can do it besides maybe a municipal or school district employee. And a lot of times governing bodies don't even know what's going on. From talking to other school board members in SDGA, I heard there was a lot of no trespass orders used during the pandemic when people refused to wear masks or didn't wear the right kind of mask. They were denied being on school grounds. They were denied going to the school. A lot of times talking to fellow school board members, they didn't even know this was going on. They had no knowledge. So the governing bodies don't even know these NTOs are being put out there. And it also opens up liability for the school district in a town, if it's a selectman. They don't know what's going on. There's liability for this being done. So there's no framework out there for these NTOs being done on public property. I know people that have been subject to these don't feel comfortable. I have not been subject to one of them, but I know people that have been, and they don't feel comfortable coming forward to talking about it. And sometimes they're in the middle of a case and they can't do that. But I do have a neighbor in Brookline who's been banned from the transfer station, and it's going on 30 months now for a very dubious event. It goes back into 2022. Even got a reminder letter that the NTO is in place just last year. So it's obviously a problem. The bill as proposed would put it as a maximum 90 days. That seems very reasonable to be able to have a public property NTO put in place. So the only thing from the original bill that I would, you could consider updating if you would want is whether it's a majority vote of a governing body to approve an NTO or supermajority, because it's sort of a standard of beyond a reasonable doubt when you're denying somebody access to the property. So should a simple majority be the one that you put forward? That's what's in the bill now as amended, or restore it to a supermajority potentially. So 4 out of 5 selectmen, 5 of 7 school board members, something like that, to make sure that it's reasonable to deny somebody access to property for 90 days. That's a lot of time. I think the bill does a great job because it gives oversight to the governing body. It gives due process if the person wants it, so they can explain themselves. As the famous saying, there's 2 sides to every story. That allows that to happen. And it puts a much needed time limit on a no trespassing order. And it does allow for a 1 year or a longer period, I think it's 1 year, if you have a repeated offender, which makes sense. So they're not going to do it every 90 days. And for those reasons, I recommend the bill ought to pass, and I hope that you find the same. Thank you very much.
Thank you very much. All set. We're all set. Thank you very much
Thank you.
for your testimony. Appreciate you coming in. Sarah Cohn.
Good afternoon. I will try to keep this short since
Sure.
we are running only a few minutes behind. My name is Sarah Burke-Cohen. I represent the New Hampshire Municipal Association. We are here to oppose HB 143 as amended. We feel like it continues to have some flaws that create an unwieldy process and are likely to create some serious safety concerns for municipalities. It's been a long day, hasn't it, for everybody? Municipalities and their employees. So looking at the logistical concerns at this point, so if a no trespass order gets issued at this point, there's some logistical issues with if there's an appeal, the person needs to get served. The best way to serve that person would be with the police. Certainly that becomes problematic for those that are transient, but becomes problematic sort of logistically, especially with a 20-day period to have the hearing, getting someone served. and making sure there is a quorum, making sure both parties can attend. I think 20 days is a very short turnaround for that, especially when many of these municipalities, especially the small municipalities, meet every 30 days. So it would be trying to get everybody together in the in-between. It sounds like a small issue, like I said, but I think it can be logistically hard for some of our smaller communities. I think the other thing to consider is at these hearings, there would likely have to be a police presence as well. People that are being issued these no trespass orders are generally being issued these no trespass orders because they are disruptive. I don't think you could have that hearing without having police presence because of that, the nature of most of the NTOs. I think that would be somewhat costly for, small municipalities. The other thing to consider is RSA 91A. We're calling for public hearings in these situations. These situations would call for discussion of someone's reputation, could be possibly negative. Both the reputation of the individual that is being issued the NTO order, as well as the individual issuing the NTO order on. So on both sides, that would be something that would be in the public. It would have to be balanced under 91A to determine what that looks like, so that everybody's privacy is protected. The other thing, to consider is if, let's just say, an NTO is issued by a town administrator or superintendent, if the governing body overturns that decision, what does that look like? That can be problematic, certainly, as well for the municipality, as it can call into the confidence. It will call into question the confidence the governing body has for that person, that superintendent or that town administrator, which then calls into question for the staff members, is this person, calls in their confidence overall and could potentially hurt the morale of the municipality or the agency. Finally, we see that appeal of no trespass orders already exists under a criminal trespass, that you can appeal a criminal trespass order if you're arrested for it. The initial step for criminal trespass is telling people to leave and issuing them sort of a no trespass order. And if they go back and are arrested, then they have an appeal right to the Superior Court. And generally, these no trespass orders could be appealed to the Superior Court. I feel like they do have a mechanism that could take that appeal into consideration. So with that, I will again say that we oppose this. We would like to, we oppose it, but also hearing what you've already said wouldn't be adverse to it being worked on further. I'll take questions.
Good, thank you. We're all set. Oh, I'm sorry.
Sorry.
Questions? Thank you, Mr. Chairman. I listened rather intently to your testimony, and I've been given some examples of some items where maybe these were issued without an awful lot of forethought because the availability was there to do it.
Mm-hmm.
I heard you say that 20 days was not enough and should be at least 30 days. And I hear that there might be a process through the criminal acts with someone's arrested. Might it also be thought, if most people have good intentions, most school boards, whatever, have good intentions, but some residents perhaps, I'm in favor of hearing guardrails, and I sort of hear that in this. And I guess I don't have a question there for you.
I'll tell you, I will answer your question that I think you have. I don't think we would be adverse to this being worked on further.
But I do want to come back to the point that it will cost municipalities money to have police there when these are heard. Almost any selectmen's meeting that I've been to that has, and I'm from further north, that has anyone in there of any contention, police force are always present anyway.
Yep.
So I raised that point. So,
Okay.
thank you.
Thank you.
Thank you for your testimony. Oh, no, you do have a question. Okay, there you go.
Thank you for taking my question.
You're welcome.
And I know we've talked about this a little bit before. Can you envision that maybe there isn't a one-size-fits-all, no trespass order situation that the city of Concord has, both the city manager and the librarian have contacted me and we've sat down about this. And that there are some situations where it's a known person and they frequent, but they're off and you've got to put them out until they're ready to come back. And there's the possibility that a public hearing in that case just exposes that person more, where it might be unfortunate. I appreciate your 91A situations, but again, the city council meets once a month. And what happens if the incident is 5 days before the meeting, not enough time for notice? So that maybe we need maybe a multi-tiered system to deal with, depending on how egregious the reason for the trespass order is.
Yeah, I hear what you're saying, and I will say what I said to Senator McConkey. I don't think we would be adverse to some more work being put in to this piece of legislation. As it stands right now, we can't support it. We're opposed to it.
Thank you.
Thanks for your testimony.
You're welcome.
Elizabeth Sargent. Always smiling. It's a good thing.
Good afternoon, Senator Gannon, members of the committee. My name is Elizabeth Sargent. I work for Champaign Capital Group here in Concord, today representing the New Hampshire Association of Chiefs of Police. I did have a lieutenant here earlier, so he would have been the expert, but he did send me some quick written notes. And I would say that the association is opposed to the bill, but I would agree with Sarah. If you would want to work on it over the summer, we'd be happy to sit down with you. And I will forward his notes to you, but I'll just quickly to get on the record. House Bill 143 proposes changes to how no trespass orders are issued and handled on public property, particularly emphasizing written notification, hearings, and a right to appeal. The bill raises a number of significant questions and concerns for law enforcement, and he talks about noncompliance issues, no trespass order issue responsibility, and enforcement questions. The proposed legislation doesn't define whether the NTO shall remain active during the appeal process or if it shall be suspended until a written response is provided to the requester. And another question we have is, can an individual be lawfully arrested for violating an NTO while awaiting a hearing? And does the mere filing of an appeal constitute an affirmative defense? So lots of questions, I feel like. Another chief emailed me and said this bill creates new requirements on police agencies to produce, in effect, a written order with substantive fact to support the order. And there's more to his testimony, but I'll get that forwarded to the committee.
Thank you.
Good. All good.
We're all
Thank you.
good. Thank you, Ms. Sargent. Does anyone else wish to testify who I didn't get to, or? Seeing none, that'll end the hearing. No. Sure, I got all the answers here. Thank you.
Ethan.
It'd be running back down if I started exactly.
Yeah.
Representative Lynn. Judge Lynn, I never know what to call you, but good to see you either way. How you doing?
Same here. Thank you, Mr. Chair. Thank you. My name is Bob Lynn. I'm state representative from Wyndham, Rockingham, District 17. And I appear here in support of HB 520, which is a bill that was requested by the Department of Education and would give the Department of Education subpoena power to issue subpoenas in connection with professional licensing, disciplinary investigations. I'll try to be very brief. Basically, I think that the basic purpose of this bill is that it seems to me just as a general proposition, if there's a regulatory agency such as the Department of Education that has the authority to regulate and discipline certain licensed individuals, in this case, teachers, they ought to have an ability to compel production of information or witnesses in support of that authority. Many other agencies have that. I just, in the office of the OLPC has that authority. I know one of the Representative Kutab is going to be here next, and she's actually done some fairly extensive research on this. As I understand it, many other states have the same authority to their Department of Education, but all of the New England states, for example, have their departments of education have authority to issue subpoenas. And I should say, because I know that there will be people here testifying against this, and I should say candidly, I'm not suggesting that there have been some, extensive problems in the Department of Education with getting information, but we did have an example at hearings of at least one situation where a school district, in connection with an investigation, refused to provide information and documents to the department, and actually told them they had to come down to the school district. And I believe, if I'm recalling correctly, that they could look at the documents, but they couldn't copy them. Not at all clear why that made sense. But at any rate, it seems to me that it just as a general proposition, it makes sense to because if you don't have that authority, then essentially what you're saying is that somebody, whether it's a licensed person or somebody who might be a witness, can tell the department when they make a request, well, thank you very much, but we decide we don't want to, and there's no ability of the department to compel them to comply, and I think that doesn't make sense. The only other thing I would say is I know in our committee there was a suggestion made that somehow giving the subpoena authority to the department would somehow violate due process. And the argument seems to be, and this is, I think, the general proposition, as I understand it, appears to be that, well, the Department of Education is the authority that can impose discipline, and so they cannot also be the sort of adjudicator of whether discipline should be imposed. They're the investigator, and therefore they can't also be the decider. I guess I would say, just as a general proposition, as a matter of administrative law, this issue has kind of been decided a long time ago in various contexts around the country. If you accepted the proposition that an administrative agency couldn't both prosecute and hold hearings to make adjudications, that you would effectively undermine the administrative law, not only for this agency but for all kinds of agencies. And the law, I think, is pretty well established that an agency can serve legitimately and in compliance with due process can serve both of those functions. So with that, I support the bill. And I just would point out one final thing. You should note that the bill contains authority to issue subpoenas in two types of situations. Sections A through E of the bill deal with subpoenas issued in the investigative stage of a Department of Education investigation, and those subpoenas are limited to issuance at the request of the department. And then Section F deals with the issuance of subpoenas in the adjudicatory phase. If the investigation ends up resulting in charges being brought, then in the adjudicatory stage of the proceedings, that's what's covered by subsection F, and that authorizes the issuance of subpoenas both at the request of the department and at the request of the person who is accused of having violated the licensing requirements. So with that, I'm happy to take any questions that anyone may have.
Thank you, Representative Lynn. Seeing none, we're all set. Thank you.
Great. Thank you.
Representative Caitlin Katab.
Thank you, Chairman and members of Senate Judiciary. I'm here to speak in support of this bill. I think that this bill is arguably one of the most important bills that we have this year in terms of keeping our kids safe at school here in New Hampshire. The vast majority of the time, teachers educate our kids and they're wonderful and they keep them safe. But when there's a serious allegation that threatens the physical safety of our kids, such as sexual assault or a failure to provide appropriate supervision and that results in physical harm, or if there's solicitation of a romantic or sexual relationship, the DOE needs to have this tool to be able to subpoena so that they can properly investigate these very serious allegations and to keep our kids safe. We heard testimony in the House that there was a former special education teacher who was convicted of child rape and indecent battery of a New Hampshire middle school student, and the department was unable to secure possession of copies of the necessary documents, which resulted in a slowing of the process to suspend his educator license. I spent a lot of time looking into this, and as Rep. Lynn mentioned, the states surrounding us all do this. And for every other professional license in our state that I could find, everybody else could be subpoenaed. Doctors, dentists, manicurists, barbers, even the people who drill your wells, the lottery commissioner, the insurance commissioner, the list goes on and on. I really urge you to support this bill and keep our kids safe. Like I said, I think the vast majority of teachers are truly wonderful. But when there's a serious allegation, we need to be able to properly investigate it and keep our kids safe. I'm happy to take any questions.
Thank you very much, Representative. Questions? Nope, you're good. Thank you. Brian Hawkins.
Thank you, Mr. Chairman. For the record, Brian Hawkins representing NEA New Hampshire, here to testify in opposition to the bill. I'll try and be brief. I do have written testimony that I'll hand in. And first, this is, I think, the third, at least, go around for this piece of legislation. We still feel that the bill is unnecessary. So there have been a number of instances where we had hearings in the House where the department was asked, was there any piece of information to take action on somebody's license that you were not able to obtain? And at least at all the hearings that I was at, the answer continued to be no. Then next, for the department is asking for the ability to issue subpoenas to solicit information during investigations. There's no provision for the educator to do that, as Representative Lynn noted, in the investigatory phase. I think that's important because, at least in the experience in talking to our attorneys who have been around since the inception of this code of conduct, hasn't been one of these matters that has actually gone to the actual adjudicatory phase that they've handled. There may have been others with educators that we don't represent, but at least that being the case. And there's also no ability for the educator to, that doesn't offer the ability for the educator to prepare, and we feel that's not consistent with due process standards. So the Department of Education is required to provide a license holder with discovery reports and documents upon which they've relied to issue proposed discipline, but providing it only if the matter proceeds to the adjudicatory hearing. And as I said, that rarely takes place. And so the next thing I just wanted to mention was the language is not restricted to certain code of conduct violations. Some past versions of this bill did restrict it to certain types of violations. And I would say the legislature is ever expanding that list of not only the code. Just earlier today, you passed a piece of legislation potentially expanding the code of conduct. And so how does that play into this? We just last year went through a rulemaking phase around the code of conduct investigatory rules. So this is like an ever-changing dynamic here. And so we think it's a little premature to add the subpoena authority there. We also feel that the reasonably likely to be material is broad, and we're concerned that doesn't have enough guardrails on it. So I think everything else, I think the only other thing I would add is we are constantly adding other statuses to teach. Earlier today, you had a debate about this. None of this applies to this only applies to this bill and other bills related to it only applies to credential holders. So part-time teachers, this doesn't apply to that. And so if we're talking about, issues of safety, which are critically important, no debate there. Shouldn't we be looking at, authority beyond just when we're creating these new statuses? So I'm happy to take any questions that I can. If I can't answer them, I'm happy to get back to you. But thank you for your time.
Thank you very much. Questions? We're good.
I do have some written testimony I'll have in.
Thank you. You
Okay.
can turn, then it'll be great. No, not Representative. Deborah House? That's okay.
Yes. Good afternoon, Chairman Garrison. It's
afternoon.
good to see you.
Good to see you.
I will try to summarize here. My name is Deborah House. I'm president of the American Federation of Teachers, New Hampshire, and on behalf of our members, we also oppose this bill. I agree with much of what Mr. Hawkins was just saying. We all agree that kids should be safe in schools, and we certainly do not want anyone in our schools who's going to harm a child. But as we have heard in testimony on the previous two versions of this bill, this is a solution in search of a problem. Not everyone in our schools are credentialed. As a matter of fact, your earlier vote today is going to allow more people who are not credentialed in our schools, so nothing about the subpoena power would help us more quickly find out information about them. From previous versions of this bill, we've heard testimony from the Department of Education, from the investigator, that there are only a small handful of misconduct cases each year that are serious enough where revoking an educator's credential is considered. And he said that they do not have difficulty getting the reports, documents, and witnesses they need in those cases. An attorney for the Department of Education testified that when investigating potential violations of the code, the department is usually able to get all the information it needs quickly. Occasionally, they have to wait. Occasionally, they have to make arrangements. Usually, that is when a school district has had to agree to work with an outside attorney to do an investigation. And sometimes that means they have to arrange to go view the material on site somewhere. But in those instances.
Would you say that Katab, when she testified, is that an outlier case?
That is an outlier case. Those are outlier cases. And in those cases, the personnel you're talking about is on leave. So they are not left in a situation where they are in contact with students. Students are not in an unsafe situation while any of these investigations are taking place. So, just want to make sure that we are clear on that. And if we're talking about students being safe, we would want a bill that dealt with not just credentialed staff, but also all the staff in our schools and the coaches who work after school and all of the staff in our public charter schools. Our non-public schools, any of our education service providers who actually interact with students through our voucher program, all of our students deserve to be safe. Another concern we have with this bill is that the guardrails of having the hearing officer who works for the Commissioner of Education approve the subpoena by saying whether it's relevant and in good faith is not really a very strong guardrail. I mean, there is a very easy possibility of the hearing officer either feeling pressured or just, wanting to give the boss the benefit of the doubt. It's very easy to see that you might agree to something that if it were a neutral third party who did not work for the person asking for the subpoena, you might get a different answer. But our biggest concern is, even though this is being presented as, yes, we want to just keep kids safe, we're concerned that it will be used for a witch hunt. There are lots of allegations about code of conduct violation, and we see being worked into more and more pieces of legislation that aren't about keeping kids physically safe. They're about someone disagrees with the approved local curriculum, or they've disagreed with a comment that a teacher made because they think it's signifying an opinion they don't like, or they disagree with a poster on the wall. We see evidence of this from the lawsuit we filed that overturned the divisive concept law that was passed back in 2021. And we see evidence of the current commissioner's role in pushing for investigations of educators, pushing local districts to investigate them. And by the way, no educators had their credentials revoked based on that. So I just want to make sure you understand that. With subpoena power, we're afraid that whoever is Commissioner of Education would be even, causing more concern and fear amongst the teaching workforce. And it would be much harder to do our jobs. We really just want to focus on helping our students learn, meeting their different learning needs, and meeting the academic standards. That's what we want to do. We don't want to be looking over our shoulders. So we really don't think subpoena power is going to make our students safer, and it's going to make our workforce much more afraid. So we're urging you to ITL this.
Thank you very much.
You're welcome.
For your testimony. Questions?
Okay.
We're all set. Thank you very much. Does anyone else wish to testify on 520? Yep. Just so I know, are you down here and I missed you, or?
Oh, no, I was
Okay.
dutifully
okay.
listening to the testimony to decide if I was needed or not.
Okay.
Good
Very
afternoon, members of the committee. I appreciate your time. For the record, my name is Diana Fenton, and I'm an attorney with the Department of Education. I'm happy to answer any technical questions. I'll give you a brief overview as to why House Bill 520 is a necessary tool for the department to be successful in handling investigations of educator misconduct. Investigations and allegations of educator misconduct do not happen every day. When they do occur, they are very serious. The department takes them very seriously. And in fact, there was one in the Concord Monitor just today, allegations from 2009 to 2011. The Code of Conduct guides the department's actions. Those are found in our administrative rules 510. And the process by which the department handles these cases is found in our administrative rules at 511. We are constantly working on our process. Last year, it was mentioned that we did go through and revise our administrative rules, the ED 511s, which provide for due process to credentialed educators. In large part, and this was alluded to in the testimony, in large part, the department works very well with the districts, and we really do value our relationship with the field and the districts. When these cases occur, it is typically the district that conducts the investigation, and that might be internal with their own staff, or they might hire a third-party investigator. It might be a law firm or a different company that will conduct that investigation. And as such, that work product the underlying report, the resulting report of the investigation belongs to the district. It does not belong to the department. And so we can find ourselves sometimes at a crossroads where there is a report produced that might have very valuable information as to what occurred, and the department does not readily have access to that report. And there have been instances where myself and the investigator for the department have been required to go to a law firm and read the report. We cannot take notes. We cannot take copies of it. We cannot take it with us. And again, we're not trying to disrupt our positive working relationships with the districts. We really do value that camaraderie and that working relationship. But the reports are work product. The reports are paid for by the district. They do not belong to the department. And there have been times, and in fact, we have a current pending matter in which we are trying to obtain access to the report. And without the report, we are hamstringed to move forward on a credentialing matter. And we do take these cases seriously. We know that the public takes these cases seriously and that this legislative body takes these cases seriously. I'm happy to answer any technical questions, and I appreciate your support and your time this afternoon.
Thank you. Seeing none, thank you very much.
Thank you very much.
Was it Eric? Yeah, I had you weren't going to speak. No, but oh, that's okay. No, there's no changes, so we're locked in. No, go ahead. Just be quick.
Thank you.
Thank you.
We will very quick. Eric Power from Brookline, former school board member in Hollis Brookline Cooperative School District, speaking in favor of this bill. I think it's about keeping kids safe. I think it's common sense. You've just heard from the attorney about why it's important. Any documents that are available should not be hidden from the Department of Education when they're doing an investigation on code of conduct. It makes a lot of sense. School boards don't always have visibility into that. A lot of times that's hidden from us, but I would want, as a school board member, I would want the full cooperation because, you know, I've known policemen and nobody hates a bad cop more than a policeman. And the same thing with teachers and administrators. Nobody hates a bad administrator or a bad teacher more, you know, than teachers. So I think it makes sense. If you look at the other states around us, they all have this subpoena authority. We do not, which is causing some trouble. So I think it makes a lot of sense to move forward with this, to give that power to keep kids safe, let our Department of Education run very efficiently, and to keep New Hampshire education improving. Thank you very much.
Thank you very much. Seeing no questions, have a good weekend. Anyone else left who I missed or changed their mind on 520? Seeing none, that'll end the hearing. Yay. Representative Lisa Major. Geez, I think I saw you around 1 o'clock and you were wandering the hall, so I apologize. Oh. Good.
Thank you for taking interest in the Senate.
Okay, Representative HB 376. Inform me and go on.
Yes, thank you, Mr. Chair and members of the committee. For the record, my name is Lisa Mazer. I represent Hillsborough District 44, the towns of Goffstown and Ware. This is a very simple bill. I'm sure you hear that a lot, but it really is. That revises one of the exemptions in our current right to know law to include but not limit to library cards and library membership status. Currently, RSA 91A-5 exempts, and I quote, records pertaining to library users, that's the current law, from being disclosed to the public, even if a right to know request is filed to obtain them. However, some public libraries are confused about our current law and think that library user records don't include library cards.
One public library even went so far as to release actual library cards to someone who filed a right-to-know request for them, and those cards were then published all over social media. Library cards contain people's names, patron codes, and information that is unique to them. Publicizing this personal information was an egregious violation of privacy, so this bill clarification would prevent that from happening again. Even Right to Know New Hampshire testified at the House hearing on this bill, agreeing that this clarification should be added to this RSA to avoid future confusion. They were not happy to hear that a right to know request was used to obtain someone's library card and membership status, and they don't want that to happen again. This bipartisan bill went through the House on consent, and I ask you to pass this simple but important revision to keep all library user records protected from public disclosure moving forward.
Thank you, Representative. Do we have any questions? Seeing none, thank you for your testimony. I appreciate your time and patience. Representative Kristen Noble. She was what?
In support.
Oh, okay. I misunderstood then. Eric, come on back down. We'll get you on the early side rather than the later side.
Thank you, Chairman Gannon. For the record, my name's Eric Power. I live in Brookline, and I am a library member in our public library. And a few years ago, we had an event which I didn't agree with. There was a drag queen event at our library. And so I went to the next library trustees meeting complaining that I didn't really like that with our tax dollars, and found out that we spent a lot of money on it. And that was my right to do as a citizen. And then within the weeks after that, some library employees, somebody leaked out my information about my library membership, whether I'd been there recently, have I taken out books, sort of as a retaliatory thing for me speaking my mind. And current law is kind of loose, so they felt like they did it and they got away with it. And I just think that was wrong. And I happen to be here for the other bills, but I wanted to share that account. It personally happened to me. So I think this clarification is really important so that it doesn't happen to other people, and that those things are confidential and they shouldn't be used in any other way, whether it's right to know or some library employee deciding to use it. So for those reasons, I hope you pass this bill. Thank you.
Thank you, Mr. Power. And seeing no questions, thank you. DJ Woody, okay. How you doing today, sir? Thank you for your patience with us.
Good afternoon, Senators. Good to see you again. Wish it was different circumstances, but I'm DJ Withy. I'm from Windham, and I'm here in opposition to HB 376. I'm a former state representative. I sat on House Judiciary. I'm a corporate attorney, and I'm a library trustee, although I am here in my personal capacity just as someone who hates bad legislation. Some of you may recall I was here on April 24th asking this committee to ITL this bill's companion, HB 666, which you did 5-0. As I said then, these bills are not really about libraries, and they're not about really protecting privacy or even preventing domestic violence, which was raised. And it's not about making a clarifying change to correct an attorney's interpretation of the phrase library usage, which I'll speak to. To the extent that these bills are about those issues, it's only at the margins. It's like the tortilla in a steak taco. It's the delivery system. But here, the steak, what we're talking about, the meat of this issue, is about a library trustee election in Goffstown. That's why we're here. That's it. Even look at the sponsors of the bill. All of them are just from Goffstown. This is a Goffstown issue. In the 2024 Goffstown election, a resident, as was mentioned, from Goffstown filed a right-to-know request with the library to see if the 6 declared candidates for the office had library cards, public government records, permits. That's what they are, permits. The library sought advice from council, and based on that council's interpretation of 91A, they released the responsive records that they had. The library did not have records for all 6 candidates. 2 of those candidates are the sponsors of this bill. So HB 376 and HB 666, which I guess is now coming back as SB 141 as part of a floor amendment, is the sponsor's response to that right to know request. In short, nobody has the right to know who does or doesn't have a government permit. Now, and Chairman Lynn was here, but when this was in the House, he asked the question, but isn't having a library card a legitimate question in the context of a running for library trustee? And the last witness answered, and her response was, anyone can ask the question, but it is up to the candidate to decide whether to answer or not. In other words, a person may ask a candidate if you have a permit, but you've got to rely on that candidate's answer. So there's no fact checking. That's what it comes down to. Before I talk about the specific language of the bill, I just want to remind you of the posture here. The 2 main sponsors have proposed legislation to protect the privacy of their non-existent government records. That is, the fact that they do not have public records should be confidential and protected. Their private information is already protected. There is no record. What they want is the absence of the government record to be confidential. I'm going to skip this part. I'll just go right into it. But in fairness, I'm sure that the sponsors would not characterize it that way. I'm confident that they would say they are introducing this legislation to protect other people's private information. Who's right? We may never know. But here's what I do know. The 4 other people that this actually happened to, the 4 other Goffstown Library trustee candidates, not one of them showed up in the House in support of 376 or 666. The people whose privacy arguably was violated didn't come forward to say, I need this protection. I mean, I'm here because I think it's a bad bill. If I thought my privacy had been protected, I would have been here. You can read that as you want, but that stood out to me. Substantively, 376 doesn't have the same grammatical flaws and other issues that SB 141 does, but it does still share the same characteristic that this bill fails to accomplish the number one stated purpose. And I don't understand that because the sponsors of the bill actually had a roadmap on how to fix this. And I assume they didn't follow it either because they didn't read what Goffstown's attorney wrote or they didn't understand it. The Goffstown attorney's opinion on 91A is publicly available, but you don't have to search for it. I brought it for you, and I'll hand it out. Among other things, and this is just something I want you to note, that this isn't some rando lawyer at a fly-by-night firm. He is the head of the municipal practice at a reputable firm in Manchester. This bill fails this proposed bill with the language. It fails because it doesn't turn on whether the phrase library usage includes library cards or library membership status. Library usage is part of an adjective string that we talked about that talks about files whose disclosure would constitute an invasion of privacy. That's the important part. That's the part that you would have to change to do what they want. So let me just wrap this up quickly by reading you some of what the attorney wrote. The New Hampshire Supreme Court has consistently held that when deciding whether a particular record is exempt under this provision, which he means 91A, the municipality must determine not only that the record is confidential, but that the release of the record would constitute an invasion of privacy. In so doing, the municipality must balance the public's interest in seeing the information versus the privacy interest at stake. And he actually gives the example here. He says, I do not see releasing the names of individuals who have library cards as an invasion of privacy, nor a violation of RSA 201D11. Indeed, since the library is a public building, anyone can enter and observe those who use the circulation desk and the card. This is different from providing access to each user's personal contact information or record showing what he is taking out of the library, both of which would be an invasion of privacy. The attorney did not say library usage, and the fact, oh, it doesn't mean library card, therefore go ahead and disclose for the 91A request. He literally says why the library holders have no expectation of privacy. And to use the card, you have to walk into the building. You cannot create a privacy interest simply by inserting a parenthetical phrase to help clarify the adjective here. The only way to give the sponsors what they want is to substantially rewrite 91A. .376 and its zombie companion bill are ill-conceived, petty, and impotent. And I'm upset to be here. I'm upset at the sponsors of the bill for treating the legislature like their personal sandbox. I'm upset at them for blaming library employees for following the law. I'm upset with them for wasting, in my view.
We're going to skip this.
I've got one sentence left. Wasting government time.
We're going to wrap it up
and
on
money.
there. Senator Evans has a question for you.
Okay.
Thank you, Mr. Chairman, and thank you for taking my question. So when it comes to the library card, I understand that the law firm provided a memorandum or a letter. What would you say the public interest is in disclosing someone else's library card in response to a right to know request?
I'll start by saying that if I had been with the representative, I would have defended her right not to have a card in that race. But what I don't see is a privacy interest in keeping that very basic information private. And I'll turn it around. In the House, the person who came from the public who testified was a member from Goffstown, and she said that was important to her to know whether someone had a library card. There was also online testimony saying the exact same thing. I don't know why it was important to that particular voter to file the 91A request in that, but I do know this, that it's not up to me to decide what criteria they use to vote and to make their selections. Your library card is a permit. It is no different. In fact, if you follow the logic, if you were to grant this, you would also, in my view, have to grant exceptions for everything, including library transfer station permits, because it says that you live in the town, you have the right to use the facility. That's it. And I also worry that if you go back, the logical implication, if you have to protect the privacy and confidentiality of a record and non-record, where do you draw the line between just saying all government records are confidential?
And thank you for taking my follow-up question. You read the letter from the attorney talking about how the library card, you go into a public place and then you use it, I guess the public can see you using the card. Yep. But I was thinking to myself, that's kind of the same as like my Visa debit card or credit card. I use it in the cafeteria downstairs, but you don't give out the number and the personal identifiable information on there. I mean, I'm trying to wrap my head around. I appreciate your concerns about what this bill does and doesn't do, but I'm trying to understand what is the public interest to get a copy of someone's library card. What public function does that accomplish? I understand you're not in a private place, but you're weighing the two. I heard reasons why.
Yeah. So
I'm not hearing any reason why someone has the interest to get it. They're saying it's important, but any hypothetical situation.
Well, I would think that for certain people, right, and library trustee is an elected position in most towns. They want to know, and they equate being a library card holder with being a library supporter. So even if I don't, even if I can draw that distinction, some people, in fact, Representative Horgan, when he came, or when he was in the House, said the exact same thing. To him, it was an important issue. So I see this permit, and if I were to weigh the public versus private, I fall in the view of open government. It is a public permit. It doesn't say anything about you. It doesn't say how often you use it. It doesn't say anything about your user records. I do not see a privacy interest. And even if I was to just say your name, you don't have a privacy interest in. It's how you hold yourself out to the world. And you've got to state your name when you come here. You have to state it when you go to the Board of Selectmen. Now, if we wanted to do away with that, I might support that, where you say, hey, it's resident A that spoke at the Board of Selectmen meeting. But in all of those minutes, those are government records. If we may just come down on different points of it, but if I'm balancing it, I tend to fall on the side of open government where I can also protect privacy.
Thank you.
Thank you very much for your testimony. Seeing no other questions, appreciate you coming in. Does anyone else wish to testify on 376 too? I knew you were going to attend when your name was mentioned. How you doing, Representative Morgan?
Oh, my ears
You
perk up.
said no, remember?
How could he know?
But
I was going to cross out, I thought I would.
keep it short. It's been a long day.
Yeah, you want to go, you've had a long day. I'm Representative Timothy Horgan from Stratford County District 10, and I was, the bill passed in committee 10-1, with I guess 7 members of the committee not being there, so I was the one, and I'm a very huge supporter of libraries, a huge supporter of, the privacy. I don't think it's really anybody's business for yours which book you check out from the libraries. I certainly think the libraries should make a full range of materials available to their users. That vote I had today, I voted against that bill in the House, and I was extremely disappointed that HB 324. I was very disappointed that it passed in the Senate. But that's it's probably on its way to the governor's desk, so that's her problem now. But I was certainly I did not enjoy hearing what I heard in the debate on the floor. I was up in the gallery, so I sort of feel like at this time, given all the attacks on libraries, both national and locally, that we probably shouldn't be making any changes in the library law at all, even one which the effect of which is somewhat ambiguous. And also, in terms of a library trustees election, that's an extremely valid issue
library trustee election. I would personally never ever want to vote for a person, no matter how wonderful a candidate might be in other respects, if they didn't, meet the basic requirement of being a user of the library. So I would, and I suppose we do pass this bill and this comes up in some other community, hopefully not in mine. I suppose you can always just directly ask the candidates if they have a library card. And if they do have one, they'll probably say, sure. Maybe even show it to you. If they don't have one, they'll probably give you some evasive answer about how it's none of your business or they don't have to have one. So, probably in future library elections in other towns, if this becomes an issue, if this bill passes, there's a workaround for voters and that. But I think certainly you do not want people, library trustees, who aren't library users. And also in general, I don't think one library user should be telling others how to use the resources of the library. Like if there's an event you don't like the drag queen event, I think the solution is to not go to that event. If there's books you don't approve of, I think the solution is leave those books on the shelf and not read them. So that's why I think I'm opposed to this bill basically because I don't think we should be making any changes in the current political climate to the library laws, and certainly the one that very possibly going to be going into effect on the effective date of HB 324. I think that was a step backwards. I don't think that was a good bill at all. So, yeah, this one's not as bad as that, but I would just say, in the issue of caution, I would urge you to ITL it. So, thanks.
Thank you for your testimony. Seeing no questions, we appreciate you coming in today. And that'll end the bill unless I missed someone who forgot to sign up or did. Thank you all for coming. We apologize for being a little behind today. Oh, yep, you're leaving, right? You weren't coming up, you were leaving. Okay, thank you. So that'll end the hearing. Thank you.
You gotta leave.
Can we exec a couple of quickies? Are you good for 10 minutes? Sure. Okay. Motion to go into executive session.
So move.
Second. All in favor of going into exec, say aye.
All right.
We're just gonna do 4.
Microphone on, sir.
Thank you. We're just gonna do 4. We're gonna start with, just give me 1 second here. We're gonna do the most controversial one first. 387, I have a motion for ITL. Do I have a second?
Second.
Okay.
Wait, 387?
Balloons. Were you here?
I've heard all about it, although
Okay.
I regrettably was not here for the hearing.
Okay, yeah. Anyways, I just think it couldn't be enforced. There were a lot of problems with the bill. You could never know if I let 20 balloons go. What are you gonna, if you found 15, I might let 100 go, but you gotta find that. There were just things that would, to enforce the thing was gonna be problematic. I realized there was good intention in not having balloons and latex balloons, getting into animals and stuff, but go ahead.
You know what the problem is, the loophole is, it says 20 or more balloons, and we just get bigger balloons.
I know you would, Senator. I know you would,
Yes,
Senator.
so that, I understand, this is not the most environmentally friendly activity. I'm not sure if it's even commonly done anymore.
It is.
It is?
Wakes and weddings. Yep.
Okay, well.
Maybe not yours. Yes,
not mine.
Senator. Senator.
I would never do that.
When it's one of your children, maybe. Go ahead, Senator.
Thank you. I agree that it's unenforceable to figure out who let the balloons go and all of that. Environmentally, I do think it's a good idea. And just as we were educated about
Sure.
cows dying,
Yep.
that maybe the public needs to be educated. And I think if we took this bill and struck out Section 3, which was the penalties,
I believe you suggested that yesterday.
and just have a little tag on those balloons that tells the person that's going to let those balloons go into the air that it's not a good idea, and that's it. We've educated.
In reality, though, do you think I would leave those tags on, or many people?
Oh, no. So when you get the balloons from the party
Sure.
store, it's
Yep.
going to have the tag on it. You
On the
probably
balloon itself, or on the
on
bottom of it,
string.
which I'd
Same
cut off.
place- Same place where the weights are. and stuff
Sure.
like that.
I just don't think the normal person in the public is going to leave the record of who they were.
No. I don't think you do that at all. I think when a store sells a bunch of 20 balloons, I'm spending way more time on this that I'm really interested in.
I know you
but
are.
When you buy a big bunch of balloons, whoever you're buying them from, the party store, puts a little tag on those balloons that says, not a great idea to kill wildlife with these. And no names, no anything, just an educational effort when you're buying a big bunch of balloons.
Do they actually do that now? Or?
I've
I don't
bought
think so.
balloons recently and they do.
I buy a lot of balloons and I've never seen that.
I mean, so to require some type of label, I mean, I guess I didn't realize this was still happening, but I guess it does to the point.
Anyways, I'm gonna move forward with my ITL motion.
Yeah.
All in favor of the ITL?
Aye.
Aye.
No.
Aye. Oh, aye. Sorry.
That's
I
okay.
on the ITL.
3-1. I'll take it out unless you want it, Senator Evans.
Oh, no.
You want me to?
I will take it.
I
will
knew
take
you
it
would. I know why you're taking it out too, but that's fine.
I like
Okay.
controversy.
Thank you for taking that out. I appreciate it.
And it's, the conversation would be Mylar balloons, Mr. Chairman. That's the product they're made of. Having sold balloons.
Okay, we're gonna move on to HB 148, an act permitting classification of individuals based on biological sex under certain circumstances. We've all seen this over and over many times. My motion is ought to pass. Do I have a second?
Second.
I
Would you
have
consider
many
saving
seconds.
this until our colleague Senator Altshuler, who would probably like to talk on this, was here?
I'd rather move it along. It'll be 3-1. We've talked about it, other bills on the floor this year. And she'll have every opportunity to bring it forth, her ideas forth on the floor.
And if I know my friend from District 24, she will let us, she'll bring it to the floor.
And she'll have more than ample opportunity there.
Yes.
So on my motion for ought to pass, all in favor of the ought to pass motion?
Aye.
Opposed? No. Okay. I'll take it out. Thank you. We got balloons. 2 to go. HB 343 was the act relative to reporting regarding the Northern Border Alliance. I am going to have a motion for ITL. Do I have a second?
Second.
Any discussion, Representative? Senator, I'm sorry.
You're moving ITL?
I am.
Fine.
You're okay?
Yeah.
Okay. All in favor of the ITL motion?
Aye.
Aye. And that was all 4 of us?
Yep.
Can I make a motion for consent?
Sure.
All in
Second.
favor of the consent motion?
Aye.
Aye. I'll take it out. And what did I leave? There's one more I want to do, Kate. 301 is what we'll do. It was the act relative to cultivation locations for alternative treatment centers. I'm making an ITL motion. Do I have a second?
Second.
Okay. Did you have any thoughts, Representative?
Only the ones that we heard in the hearing that it would allow for not only inventory, but more ability to, because we only have 10 locations in the state of New Hampshire, and there are a number of patients that live a long ways from there, being able to get the product that they need at any one location is more likely if that location is able to grow more at a cheaper price.
Very good. So we have a motion of ITL. All in favor of the ITL motion?
Aye.
No.
Okay, thank you. You want to take it out? I'll take it out either way.
I can take it out.
I'll give it to you then. Senator Abbas. Motion for consent? No, I didn't. Good try though. I like that. Otherwise, that's all we're going to do today. Thank everyone. Thank everyone we apologize for being a little late today. Motion to move out of exec unless you have something else.
Is there anything else you want?
No. The reasons we don't.
Motion to go out of executive session.
Thank you.
Second.
All in favor of the motion to go out of exec? Say aye. Aye. Thank you all for your patience. Thank you, Pete. Thank you, public.